Good afternoon to one and all present here. Today we have another session in which we are featuring Advocate Rahul Tiwari. Before moving forward, I would like to introduce LexPeeps to you all. LexPeeps Private Limited is an organization that works to assist and help law schools in organizing and managing their events. We are seeking to provide young and dynamic law students a platform to experience the legal world in their academic capacity. We organize different events where budding lawyers can experience the legal world with a self-directed educational strategy and the guidance of industry experts. LexPeeps also provide you with the recent happenings in the legal world in the form of news, opportunities where you can find what suits you best, articles to explore your interests, and many more. We are also into organizing courses for law students. Recently, we have organized our course on intellectual property rights. Before moving further, I would like to extend thanks to Advocate Rahul Tiwari for coming to this session. Uh, uh, there are no words in which I can actually explain the about Advocate Rahul Tiwari, sir, but still I'm putting in my efforts. Advocate Rahul Tiwari has completed his legal education from Law College, Bharat. He has also obtained his LLM with 8.35 GPA, training holder specialization in cybercrime and recording software. He has a strong passion for research and public speaking. He is founding and managing partner of LLS Associates, which is IMCA registered law firm. This firm also offers online legal education and training to law students and fresh graduates. He is also a panel member of World Cyber Security Forum. So, a very thanks to Advocate Rahul Tiwari sir for joining the session. Now, sir will be taking it forward.
Can Hello everyone. I guess there is some issue. Uh, I guess not. There's some noise issue either from my side or your side. If I'm not, is it
So, sir,
resolved?
I yes, sir, I think it will be resolved in another 1 or 2 minutes.
Yes, yeah. Just check it because you know that cracking voice is coming on the background. Na? Just check
Now,
about that. Yeah.
now I think it will be fine.
Okay. Yeah, it's perfect now. So I'll request you can mute yourself now,
Surely.
and if I ask any questions from the participants, so will they be able to answer?
Yes, sir, they will perfectly be able to answer through comments in the YouTube.
Okay. That's Acha. Okay, here are the participants. Okay, fine. So before we move forward, like so today's this is my 50th webinar, as you know, and that's why I chose a topic that which is not much given much relevance, and that's why I thought that I should discuss with this. I should start with this topic actually. So hello everyone, my name is Advocate Rahul Tiwari again. I'm a practicing advocate at Gurugram District Court. I'm a founding member of a law firm also, and also I'm an educator. I'm an educator at Study IQ, where I teach judicial service aspirant, and also I've launched my own courses also. So, uh, so much of background. Yes, that's what I told. So, am I audible now, everyone? 506. Okay, yeah, it's fine now. So, yes, I'm recently I've joined Study IQ also, which you all know. It's one of the biggest platform for online education as an educator, and I'll be teaching the judicial service aspirant, mostly the criminal law and the local law of the states. So that's where I thought that I should pick up a topic which is not much discussed. So that's and today I've kept just more of an interactive session. So this is the webinar talks about expert evidence, and if all of you, if you wish to join criminal litigation, see there is a perception which is being built that you need to have a good contacts, which is there. You need to have. I'm not denying that thing, but at the same point of time your knowledge and your research skills also matters. If you think that just because of your background or your contact you will be able to survive this field, then I'm really sorry, you are wrong. And again, if I ask someone that which is the most important subject for in the criminal law, especially the criminal law, then the blunt answer I get is either CRPC or IPC. which is there. CRPC and IPC actually defines what is the criminal law is all about. But at the same point of time, for me, one of the equally, if not the most, but equally important as CRPC is Indian Evidence Act, and the conditions of, and in the even the Indian Evidence Act is also applicable on the civil laws also. It's not that Indian Evidence Act is just applicable on the criminal law itself. It's not the case. So the point is today's webinar is on expert evidence. May I know if anyone can mute and answer? Can I ask anyone like, okay, uh, no, Amrita Monty is my student, so I expect her to know the answer. It's not that because she's my student, she knows the answer, but she has helped me in a lot of my, in a lot of research work and in my module preparation, which I prepare for, which I teach my students, through which I teach my students. So yes, I know the answer. So yes, Roshni Agarwal ma'am or Priya Khodwave ma'am, can you please tell me that is expert evidence is actually a evidence or not? If it is okay, otherwise I can move forward. Is the point is that today's webinar is a bit long. The duration we have kept for 2 hours. So that's why I thought that let's make it more interactive. So that's why I thought that if it is okay, if they can answer that if it is possible that expert evidence is actually an evidence or not, because that's the theme of this webinar, right? That's the topic of this webinar. Anyone, please give it a try. And it's okay even if you're wrong, and that's why, like I said, this is my 50th webinar. Okay, so I'm well versed that good evening everyone here. So I'm well versed that how the student feels, and it's okay, it's completely okay to be wrong. So but at least you please give it a try. That is okay, Roshni ma'am, I said yes, expert evidence is an evidence. Okay, anyone else wants to try, who wants to add something new to the answer? Anyone? Okay, no problem. First of all, the thing is, we generally say that okay, this is an expert evidence, this is an expert evidence, and this. But the thing is, when we read Indian Evidence Act, see, I have just taken out a few xerox of my from the Bear Act, and I've just written few of my observation. Okay, and the best way to study law, because I'm also teaching judicial service aspirants also. See, the thing is, although I'm just 28 years old, I will also appear for judicial service examination. Okay, so fingerprint, Vijay Lakshmi ma'am, yes, it is one of the aspect. But see, now the point is to make things clear. When we say expert evidence, it's not the case. We have kept this title just to make you understand that yes, expert evidence. But the thing is, it is defined in Section 45 of Indian Evidence Act. Yes, Nidhi Chiller, ma'am. Yes, it's the right answer. It is the expert opinion. It is always the advisory, where the expert always advise the person about not the person, about the court, about the circumstances of the cases, and it can be related to anything, whether it is foreign law or any science or any evidence which requires the observation or the advice of an expert who can actually tell, who can explain the court about that circumstances. It can be medical expert also, it can be handwriting expert also, it can be fingerprint expert also. So, and their evidence are not, see, if someone asks that is expert evidence are admissible in nature, I would say it depends on the facts of the cases. But what is the evidentiary value? There are two things, admissible and evidentiary value. If someone asks you that what is the evidentiary value of an expert opinion, then what will you say? You will say that expert opinion, it's just an advisory in nature. It helps the court in forming an opinion. So the formation of the opinion will always be done by the court, no matter how much an expert gives stress upon any evidence or through any of his research. Why? Because opinions of expert can vary. If there is a given circumstances, Okay, I can say that, okay, I can give multiple advice on that particular matter. Like suppose, for example, if someone takes my expert opinion, just suppose I'm just dealing like an expert to a normal person, and if he asks me about a check dishonor case, okay, that this is a check dishonor, it has got dishonored, now the limitation has passed. Okay, now the limitation has passed. What should I do? Like, I've not sent the notice on time. So same situation, I can give two advice. First, I would say that yes, do one thing, go and file a civil case now for suit for recovery. Or I would say that, okay, give me more points about your case. Maybe I can help you in filing. Maybe I can help you in filing a criminal case by first moving in Section 5 application of Section 5 of Limitation Act, so that where I can convince the court, that a lot there has been a sufficient ground for the delay for filing of the application. Okay, so these are things where we have to look up to. So that is why expert opinion are always advisory in nature. They are not admissible unless and until the judicial officer feels like. Okay, so this is something which you should always remember. Now, let me read out a few the lines of the Barrett, and I'll make you understand how do we read the Barrett and how do we understand it. Okay, so Section 5, opinion of expert, means where the person, where the court has just asked for the opinion of the expert. He has not asked the judgment, because it is the judge who is going to give the final judgment. So let's read out what does the Bare Act says. And coming back to the same, that what is the actual way of reading the law. Actual way of reading the law is to always start with the Bare Act. Read the Bare Act. And now I know reading Bare Act is a bit troublesome, especially for the students. It's a bit boring also. But the thing is, that is the correct way of reading the law. Okay, because suppose if you are not reading, suppose you are reading IPC, Indian Penal Code, and you are not reading the Bare Act, but at the same time, instead of reading the Bare Act first, you have straight away opened KD Corp. So that's where you are not reading the IPC, you are reading the KD Corp's interpretation of IPC. The real way, the actual way, is to first read the Bare Act, and after reading the Bare Act, first understand what is the basics. Because like any author, all the like any other human beings, all the authors are biased in nature. They will tend to be biased over a particular issue. No author, even I have presented 25 research paper, I have got 7 research paper published also. Okay, so I know that at some point of time, being a human being, a person is tend to be biased. But that's not the case with the Bare Act. So that is why first read the Bare Act and then open the book. That is the correct way. Otherwise, if you think that if you just read the books, read the commentaries, and you'll do well, trust me, somewhere down the line, your basics will never be clear if you don't start reading the Bare Act first. Now let's see section 45. It says opinion of experts. So when in the first 3 words it has written opinion of expert, means the court is just asking their opinion, and it simply means that it is on the discretion of the court whether to accept their opinion or not. Why? Because they are the expert. They just help the person. They just help the court to to come to a conclusion. So who is an expert? An expert who gives the advice to the court. Very simple language, I'll elaborate it. An expert is a person who advise the court to form an opinion of the case. Now, expert opinion, I'll give you a judgment also, and I hope you guys are carrying your notebook and pen with you, because I'll dictate 3-4 landmarks. Okay, so please don't miss out. So in one of the judgment, I'll tell you the judgment later, and it was clearly held that expert opinion the solely the expert opinion cannot be the sole basis of the conviction of the case. Just because an expert has said something, okay, expert has said something, so we'll conclude. Why? Because expert opinion is always considered as a weak evidence. For example, in one of the infamous case, I would say in the Jessica Lal case, remember the many experts, what did many experts, what did they told the court? That the shot, the bullets which was fired on the Jessica Lal by the prime accused were fired from two guns. So that is where it is always accepted, it is always it's an established fact that expert opinion is just for the court just to take their help and form their opinion. It is never the conclusive one. Now, which is the best evidence? Now, and when I'll reach the medical evidence part, I'll teach you how the court varies its opinion, but still how we have to still stick to the basics. Medical opinion, there are a lot of expert, we can say that in many instances a lot of evidence are taken into consideration during a trial. But in the court, can anyone try which is called the best evidence? The best evidence, that this is the best evidence which the court always relies upon. Anyone? And then we'll start, okay, because we'll start in like 1 hour and then I'll take your questions, okay. Which is by the court, which is called the best evidence. Anyone? Come on, give it a try. The best, okay, fine. The best evidence by the court is, can anyone, please? Roshni Agarwal has said eyewitness. So, what do you call eyewitness? There must be some name of those kind of evidence of the eyewitness. Yes, eyewitness is the right answer. But what is the name? What is the legal term? Nidhi ma'am, sorry, this time you got it wrong. I feel it is called ocular evidence. Just go for SSC online and or live law and read this. Document evidence, no. DNA is also no. Just wait. On DNA, I'll give you a judgment. So ocular evidence, the evidence, the eyewitnesses is called as it is always considered as the best evidence unless and until the medical evidence rules out all the possibilities. Please write down this judgment. It just came recently. Just write down this judgment. In Jayanti Bhai, in Jayanti Bhai, Bhai, in Jayanti Bhai versus Dinesh, Jayanti Bhai versus Dinesh, Supreme Court, AIR 2021. It was held that ocular evidence, OCULAR, ocular evidence are considered as the best evidence, are best evidence, and and it is to be disbelieved. It is to be disbelieved only when all the medical evidence all the medical evidence rules out all the possibilities. Means here, if medical evidence rules out the possibilities and helps the court in coming to a conclusion that the person who is stating himself to an eyewitness of the case is lying or is giving false evidence to the court. If it is proved to this level, then medical evidence or the expert opinion will be taken into consideration. Otherwise, otherwise, in the judgment of, right, in the continuation, in the judgment of Mahmood Mahmood versus State of UP, State of UP, Supreme Court, AIR 2007. AIR 2007. It was held that it was held that whenever whenever there is a there is a contradiction there is a contradiction between medical evidence and ocular evidence, then the primary with the primacy then the primacy will be given to ocular evidence. Okay. Otherwise, see, now you understood. Like, this is the medical evidence. Medical evidence, it is admissible in the court if it helps the court to form an opinion. Otherwise, if there is an ocular evidence and there are contradiction, so unless and until now we can combine both the judgments. Now see this in Mahmood versus State of UP. Supreme Court said 2007. In 2007, Supreme Court said whenever there is a contradiction between medical evidence and ocular evidence, then the ocular evidence will be given more priority, and it all again it depends on the facts and circumstances of the cases. There is no hard and fast rule though. Okay, because in the cross examination there are chances that the opposite counsel or the defense counsel or the opposite counsel can prove the court that the person who is stating himself or herself to an eyewitness is lying. Okay, otherwise in any normal circumstances the ocular evidence will be given more preference, and there was a continuation in the same theory. Only the thing is that the Supreme Court itself just elaborated the term, just in the furtherance elaborated few points, and again in the judgment of Jayanti Bhai versus Dinesh, Supreme Court just said that ocular evidence are the best evidence. Supreme Court is still saying that ocular evidence are the best evidence, but it is to be disbelieved only when medical evidence rules out all the possibilities. Only then medical evidence will be believed. Otherwise ocular evidence will be given preference. So both the judgments are same, but Jayanti Bhai versus Dinesh, in this latest judgment, Supreme Court just in the explanation part just went one step forward. That's it. Now, very quickly, section 45 of opinion of experts. So now I'm reading the Barrett for you. When the court has to form an opinion upon a point of, now it means, and see how do you read the Barrett. Whenever you read the Barrett, now just a second. So whenever you're reading a Barrett, the best way to understand the Barrett is that if there is a sentence, there will be a lot of commas. So divide the sentence into small parts, okay, and then read it. And if the first word is of the Barrett is of the particular section reads whosoever, it means that particular offense or that particular section is gender neutral. Otherwise, when you read about rape, section 375, the first word which you read is a man. Okay, same is the case. And see, these are few tricks. Okay, and obviously I'll tell you. And for this purpose only, I'll humbly request that just please connect with me on LinkedIn. I'll just, if it is possible, I can share my LinkedIn. I can share my LinkedIn profile with you, and also I have launched a course. I've taught more than 4,000 students for free of cost through webinars, and I have taught more than 1,000 students through my paid courses. Please, I will request connect with me on LinkedIn and see the feedbacks of my students. And also I'll share the links of my course where I will teach you all the important aspects of CRPC and drafting, Then legal research, how to draft moot court memorial. I have just more than 15 moot court competitions, and all the important parts, all these just the important parts of the CPC. It's a 1 month course. Even if you have exams, the classes are on, or classes are both online and offline, especially for the Delhi NCR students. Classes are both online and offline, and also the classes are in evening. And if in any case, because of any commitment, you miss out on any class, then also for every recording will be available to you for 15 days. So even if you have exams, you can still enroll in my course. Okay, it's a 6-week course. For 30 days I'll give you 12 live classes, 6 recorded sessions. Uh, for all the classes, recordings will be provided, and for 15 more days. So the total duration comes out to be 6 weeks. And also, one more thing, please also compare the price of my course, okay, with all the other educators available online. Okay, please compare the price of my course. It is less than 100 rupees a class. Okay, please compare the price of my course, and please connect with me on LinkedIn, and definitely I'll share. I have, you can see the feedbacks of my students, and definitely you can enroll. Now, moving forward. So now, the sentences, first I'll read out the complete sentence, and then I'll tell you how do we read the Barrett first. When the court has to form an opinion upon a point of foreign law or of science or art, or as to identify of handwriting or fingerprint expert, the opinion upon that point of person specially skilled in such foreign law, science, art, or in any question as to identify handwriting or fingerprint are relevant fact. Now, if you read Barrett like this, in this life it is impossible that you will be able to understand law in one lifetime. It will take you like more like 2 to 3 lifetime to understand what is law. So how do you read the Barrett? First 3 lines. Opinion of expert means here the opinion is taken into consideration of expert, means the opinion is the primary fact. Now, when the court has to form an opinion upon a point, means here the court wants to form an opinion, means on which points, on foreign law, or on any science, or on any art, or in, or as to, means, or to identify any handwriting, means handwriting expert. In the bracket you will see fingerprint expert, and the opinion to that point of person. Opinion, now the comma, and after it's written, the opinion upon that point of person specially skilled in, means here itself the Barrett says the first criteria of the expert, means the person should be skilled in foreign law, science, or art, or in any question is to as to identify of handwriting or fingerprint expert are relevant, means to the fact of the cases. The court takes the opinion of the expert who are skilled in either in foreign law, or in science or art, or they are in handwriting expert or fingerprint expert are relevant to the facts of the cases. In some in now I'll elaborate here. The code, the this section 45 means to say that who is an expert, and means the expert is a person who has acquired a special knowledge or a skill, or has experience or has training about any foreign law, or any art, or any profession, or has done extensive research over that particular issue for a considerable period of time. So the court generally calls upon those kind of people. When when do they uh, when uh, court calls upon that kind of person, when the person is not when the court is not able to form his own opinion. So that time the court invites such persons, takes their advice. That's it. That is the only job of expert. There the court, those expert gives their opinion about that particular issue. If it is related to any foreign law, or if it is related to any medical evidence, or if it is related to any scientific thing, or any forensics, or handwriting expert, or fingerprint expert, okay, or anything related to it, they just give their opinion. Then court records their opinion, but it is again at the hand of the court. It is on the discretion of the court whether to accept that opinion or not. Means the court just take their opinion just in order to, so, and their job, the job of the expert is just to assist the court so that the court comes to a conclusion. That's it. The expert job is that much only, because the expert cannot say no, no, this person has only has committed the crime. No, he's an expert. He's not an advocate who can explain the law, or who can explain the facts and circumstances of the cases. No, nothing else. Only the opinion about that particular thing, or in which he has been an expert. That is it. Now, who is really an expert? I've told you the character, and always remember uh, the evidence, the expert evidence. That's why we call it all this an expert evidence, but it is only the opinion. So the evidence is only in advisory character. Write it somewhere. Expert evidence is only in the character is only of advisory nature. That's it. And moving forward, and what is the credibility? It depends, like what kind of advice the court has asked, and whether the court accepts or not. So court collects all the expert collects all the data, or he understands the fact, and he just gives his opinion. Now it's on the duty of the court whether it formulates, whether whether it accepts his opinion or not, to formulate the opinion. Okay, so that's why on see, that's why when the court calls an expert, that person is an actual expert, whether the court accept his advice or not. But all those experts which you see on the news channel, where the news channel invites the anchor, and they make small boxes. In one box there is one expert, in one box there is one expert, and and he just take the advice, and he just do the all the entertainment stuff, and just they just distort the fact, and they just do nothing but just conduct an unconstitutional media trial. Okay, so like moving forward is just remember, like so all those experts which you see on the TV, they are not the actual expert. In fact, it was so horrifying to hear, like few of my colleagues, they had paid huge money, just to appear on national television, so that they can tempt. Earlier I used to think that, okay, this person has called, has been invited by this news channel for this and that. Later on I find out that this is the situation. Then okay, so please, those are not expert mostly which you will see on TV. Otherwise, the because see, on TV, okay, I'll explain this one. So because you will not find these big respectable advocate coming on the TV regularly and giving the opinion. No. Otherwise, say suppose, for example, just take an example of Siddharth Luthra sir. Okay, he will not come on every second or third day on the TV to explain about any cases, or being a legal expert and give his opinion on particular television. No, but if it is related to his case, if he is invited to speak on that matter, he will come and he will explain without revealing all the evidences. He will explain the stand of his client, and also what, and he will explain what is the law. That's it. But he will not go and come and entertain all these stuffs. So yeah, and one more thing, like who is the actual expert now? Recently you should see in the news channel, there is an IPS officer in Uttar Pradesh. His name is Triveni Singh. Now he's been on that person. A web series is also being planned, and maybe you will see a web series also. You'll see a web series also on that particular IPS officer. Now, why the expert opinion is also called a weak evidence? I told you an example of Manu Sharma case. I will humbly request you to please watch this web series Illegal. The name of the web series is Illegal, and the famous actor and actresses are Piyush Mishra, obviously of the gang of Wasipur, and that actress Neha Sharma. Means and shows that Piyush Mishra is a very good, he's a prominent advocate, and how the law firms work, and he's basically a criminal lawyer, and how the law firm or the legal system works in India. And also, when I'm talking about legal system in India, I'll request all of you guys, please stop watching Suits. By watching Suits, you develop an unnecessary expectations about yourself, about the Indian legal system, and when those kind of students come for internship, they just do nothing. I mean, they just create trouble for the seniors. So I've seen a lot, and especially among my students also. So because I've been asked very stupid questions. So that's why I keep telling them, please stop watching Suits. Okay, it is not at all relevant. It is not at all relevant in Indian circumstances. Also, the nearest picture which you can see about the Indian legal system is that web series illegal, and in that also their expert was called, who later on, and that's why if someone asks, if you're asked with a question that can the expert opinion be ruled out in cross examination, write it somewhere. Yes, expert opinion can be questioned and can be ruled out during the cross examination if proven false. Okay, first thing. Or if proven false, or if proven contradictory, especially in the web series also, because it was a case of a rape. The trial was on the rape case, and the expert was the prosecution who called the expert. Later on, it turned out that the expert and the prosecution were friend, and the same expert used to come used to come on his call, and he has appeared, and he has given expert advice in more than like 20 of the cases of that same prosecutor. So the actress, the Neha Sharma, who was acting as a defense counsel, was able to highlight this point. And told that obviously, because he is an expert, he's a medical expert for any given circumstances. Even for the DNA part, it was revealed over there. For any given circumstances, an expert who is a skilled person, who has experience, who has gained significant knowledge in that particular field, can give multiple advice on the same problem. Okay, so now one of your colleague has asked that what is the difference between recognized as a person witness and expert witness. Person witness will not say a person witness, but it is an ordinary witness. Or the and second is the evidence. So expert opinion is like, suppose there is a trial going on. So the party to, there are like A and B, A versus B, the case is going on, and evidences, the witnesses are C, D, E, and F. So those are the ordinary witness who have to testify, who is the accused, or who has to testify with the whether the weapon used in the offense, or anyhow they are related to the case, but they are witness, but they are not expert. Why? Because they cannot give conclusive advice. They cannot give conclusive advice to the court. And obviously, as they are witness, it becomes highly prejudice, I would say, the prejudice to treat the same person as an expert evidence also, and as an to treat an ordinary witness as an expert witness also, even if he's well educated, or he's well skilled to fit in that role. So that way, that is in that situations, the court, that situation, yeah, in always in other situations also, the court always call for independent uh, evidences. Like again, I'm saying government doctors. Yes, government doctors are one of the experts. But again, medical evidence part, I'll give you a judgment also, and I'll explain the difference between medical evidence and then DNA evidence and then polygraph test. Okay, just please be for a second. So again, I have told you it is just an advisory nature. Summing up, it is always the scope of expert evidence are very limited. Okay, and obviously they just gives, and their job is only to help the court to form the conclusion. Okay, can I write something in chat? Like, I'm not sure, I don't know if I have to comment something. No, Vijay Lakshmi, I mean, I have not completed. I'll give you an example now. Can I write something in chat? Okay, I'm not able to type anything.
So that option is not for the invited speaker.
Okay, Okay, with the speaker, I mean the speaker will just come and speak and then go. Yeah.
If you want, I can type it for you from my end.
No, no, it's all right. But there was something. No, no, I had wanted to share my LinkedIn ID and my course link also, so that they could have seen. But it's fine, no issues in that. So now
Uh,
moving forward, what kind of first evidence? Like usually, those evidences where the court take into the consideration, which are handwriting expert, ballistic experts, handwriting expert, fingerprint expert, because more in those cases, usually when the court takes into the consideration, take because they usually take the forensic help and from the opinion, and usually in most of the cases the advice given are absolutely accurate by the forensics, and there is a corroboration of the views given by the expert as well as the forensic teams. But whenever it is not the case, usually the forensic teams are given more preference. Why? Because an expert away, because the court takes the advice of an expert to understand a particular thing, and that is why, because this is law, and because the way the society is moving forward, the way the science and technologies are advancing, the level of crime, or the the variety of the crimes, especially related to science, is it is diversifying. So obviously the court also need experts, and court also need experts, and they take their advice just to form the opinion. That is it, not more than that. Now when we talk about medical opinion, then what do you mean by medical opinion again? Then the medical evidence also, please remember, medical evidence are also expert evidence. Medical evidence are something that which can be admitted also, it can be denied also. Always remember this thing. Okay. And where the medical evidence are taken into consideration, where it is taken into consideration, just to understand the physical condition of a man, to understand the nature of the disease, to understand the cause of death, to understand the effect of the poison. Suppose if the poison is used to kill a person, then what is the effect of the person, and then the nature of the injury and the nature of the weapons. That is it. Here also in the medical evidence, again I'm stating you, in the medical evidence, the court takes the medical evidence just for the advisory purpose. That's it, just to form the conclusion, and they are not the conclusive evidence, they are the weak evidence only for the advisory purpose, and solely the evidence which I would say that solely on the basis of expert evidence, the conviction can never be granted. And again, another Supreme Court judgment, please write it down, Malay Kumar Ganguly, just write MK Ganguly, MK Ganguly versus Sukumar, Sukumar Mukherjee, Sukumar Mukherjee, AIR 2010, AIR 2010 Supreme Court. It was held that it was held that medical evidence can be admitted or it can be denied, and how much weightage, and Vijay Lakshmi, it's for you actually. You had asked for the government doctor, so this judgment will help you clarify a lot of things. And all these judgments I'm giving you just from the Barrett, and just I have written few more points from my observation. That's it. So this is how important the Barrett is for the law students. So how much weightage, how much weightage, how much weightage should be given to an expert, how much weightage should be given to the medical evidence depends upon the court. Okay. And it should be treated like any other evidence. This is the observation of Supreme Court. Okay. Now again, I have told you, and obviously ocular evidence and all these I've explained, that if there is a clash between ocular evidence and medical evidence, the ocular evidence will be given in the preference. Now moving forward, And also in this, I would write down one more judgment in Munshi Prasad. In these judgment I have taken from a few books. In Munshi Prasad versus State of Bihar, in Munshi Prasad versus State of Bihar 2001 Supreme Court, it was held that medical evidence, medical evidence or the post-mortem evidence post-mortem evidence is not a substantive evidence. Means sole conviction cannot be given just on the basis of medical evidence. Why? Okay. This is, although it is important, it is an essential evidence, but it is not. The court has said that we cannot clearly say that yes, on just on the sole basis of the advice of the doctor on the just on the post-mortem report we can give the judgment. Okay, there are a lot of other things, and why in most of the cases medical evidence medical evidence are invited by the court. It is why because imagine like this, that we have the judge, he just wants to understand. If he reads the post-mortem report, he just wants to understand how the injury has been caused, how uh, what is the nature of the injury, and what was the reason of the death. And post-mortem reports they act as a very important piece of evidence. Why? Because they are the one who actually helps the court in understanding the nature of the injury. So the court can, okay, the court can understand that, okay, whether the death has happened due to previous hurt, whether the person wanted, if see, the post-mortem report, it will just give you one thing, that the death has taken place. Why? The death has taken place only because of this injury which was inflicted by this person. Now the post-mortem report says that this person inflicted injury to this person. Here, the post-mortem report is clearly stating that the death has happened because of the injury which has taken place, which was given by this accused. Now, the accused should be given death penalty, or I mean, he should be convicted under Section 302 for murder, but that's not the case. Write down one more important judgment. In Palani Gaden, Palani, Palani, Palani Gaidan, Gaidan versus Emperor 1919. 1919. It was held that if, while inflicting the injury, if both intention, if both intention and the knowledge, both intention and the knowledge are absent, then the death caused and the death is caused, if both intention and the knowledge are absent and the death is caused, then the person shall not be convicted under that the person shall not be convicted under which let's say it will not be convicted for the offense of murder, but for the offense of but for the offense of voluntary causing grievous hurt, section 325. So there was an alteration of charges. Okay, so this is an important. Why? Because the court took the post-mortem report for the consideration. It understood that yes, it is for the injury. Now, while inflicting the injury, whether the accused has the intention to kill a person, or whether the person has the knowledge that whether his action can cause death to a person. Why? Because the accused has hit the deceased with a plowshare, whether it was a wooden stick. And in any given circumstances, a normal person cannot even think that a normal person cannot even think that no, that by hitting someone from a wooden stick on his head, the person can die. Okay, so this is the reason why expert evidence are just taken into the consideration. They are just advisory in nature, but the conclusion is always has to be formed by the judicial officer only. It is on the judicial officer whether he can accept the evidence or not. If the judicial officer the would have accepted the expert opinion, if it is made mandatory, suppose what will happen if it is made mandatory for the judicial officer to mandatorily accept the expert opinion, then what would have happened? Pardon, sir. Yes, Roshni ma'am, tell me. uh, Roshni Agarwal ma'am, you have written pardon, so do you want me to repeat something? Please write in the chat box. Please write on the chat box, otherwise I will have to move forward. Motive preparation, case explained. Okay. Palani Garden. See, Palani in this judgment, what happened that the husband has what he did, that he hit his wife with a plowshare. Okay, it was a wooden rod, but it's something that you cannot cause death to someone, and the wife fainted. So he thought that his wife has died. He didn't had any intention to kill his wife. He didn't had any intention to and he didn't had even had the knowledge that by hitting someone from a wooden stick, the person can die. Even in the judgment of Dhyaneshwar versus state of Maharashtra, similar thing happened. The person has hit the another person. The person has hit the another person by a wooden stick of 210 grams. So again, both intention and motive were absent. Okay, although the wife, the reason for the death of the wife was different. If I tell that, and then I have to explain few more other concepts, so you'll get confused. Just understand this thing. The reason was of death was something else. Okay, so but at that time he thought that he has killed his wife. Okay, and obviously he was arrested for it, but it was found out that till the time his wife has fainted, till the time his wife fainted, till that moment he didn't had any intention or knowledge that uh, till the time he didn't had any intention or knowledge that he has killed his wife. He didn't had any knowledge. Then what he did? Okay, I'll explain it. Then what he did? He thought that now wife is dead, and he presumed, and he had the mistake of fact also, which is excused, that it is a dead body now. So he hanged the dead body to show the police that his wife has committed suicide. In post-mortem report, it was found that it was found that the reason for the death of his wife was because of hanging. Why? Because the person, when he has hit his wife with a wooden stick, she just fainted. She didn't die, and the person presumed her to be died, to be that she has said she has died. So he hanged his wife, and then his wife died. So that's where both intention and knowledge were missing. He didn't cause death up till the time she fainted. He, to the best of his knowledge, he was hanging a dead body. So that's where the charges were altered from culpable from murder to voluntary causing death. Okay, and also along in this case, one more offense was done for fabricating the false evidence, means inflicting false evidence, section 192 of IPC. Okay, now moving forward, as I've explained that now this is where why medical evidence, because if you go to any doctor for same disease, a doctor, if you go to a government hospital or a doctor who has a good reputation, or who is a bit honest, if you go and tell this disease is you're suffering from this, the doctor can advise you this thing. Okay, take this medicine, and do one thing. It looks a bit serious. Go and conduct this X-ray test and these 2 3 tests, and come to me, and I'll examine. If it is, if there is a reason to get operated, I'll operate you. Otherwise, if you can, if the disease can be cured by medicine, just take the medicine. The good doctor will say like this. But if you go to any private hospital, recently a news came that where a private hospital has billed 1.8 crore rupees from a patient. So if you go to a private hospital, same disease, the doctor will say this test, and instead of treating that medicine, because the doctor is an expert, okay, he can treat the same disease by by conducting an operation also. And if he is conducting an operation, he gets the more money. So that is why the court just take their opinion, they just take their advice, they just take the help of their knowledge, but the formation of the opinion is always with the judicial officer. Okay, all these things, because if you join my course, my classes will be of 4 hours each. So you'll just I'll request you to please first connect with me on LinkedIn. Just type advocate Rahul Tiwari on Google. Just type advocate Rahul Tiwari on Google, search me on LinkedIn, connect, please connect, and then I'll share you my course detail also. And recently also, just the day after tomorrow on 22nd, I have a similar workshop with Symbiosis Hyderabad, where I'll be teaching the LLM students about the criminal litigation, okay, of Symbiosis Hyderabad. Okay, but because I cannot send you the link over here, otherwise I would have sent you. Now, the point is medical evidence done. Now comes DNA evidence. So how come at one point of time DNA medical evidence, which is an established science, medical evidence is an established science, but there the medical evidence is always an advisory nature, but DNA evidence is taken as a conclusive proof. How? Because DNA evidence is what? DNA test is the actual proof of paternity or legitimacy of the child. It cannot be altered. Okay, and with the DNA also, the evidence of the DNA expert is admissible. Expert of DNA evidence, evidence, or write it down somewhere. Evidence of DNA expert is admissible. Why? Because it is a perfect science. It is an established science about the DNA. Nothing can be changed. That is why the first exception comes while dealing with the DNA medical evidence is that in medical evidence, the court can accept or can reject the expert opinion. But in DNA evidence, as it is a perfect science, the court accepts the expert opinion. Okay. Now, how about brain mapping test or polygraph test? What will happen? You are doing a brain mapping test just to see the authenticity or whether the person is lying or not. Write this judgment, again Supreme Court judgment, in Ranjit Singh, in Ranjit Singh versus versus state of Maharashtra, state of Maharashtra. It was held that it was held that it was held that admissibility it was held that admissibility of scientific test admissibility of scientific test will depend on authenticity of the test. How authentic was the test, and what are the other criterias which were related to that particular test. Okay, so the court analyzed these things, that whether, like, suppose someone is conducting a polygraph test. No scientific tests are perfect. Okay, not all, like unlike DNA. So the problem is that the court sees that whether it was done properly or not, whether it was, if it is taken from the consent, if it is taken from the accused, the polygraph test or the narco test. Okay, if it is taken by the accused and the accused is been denying the narco test, the accused is denying the narco test. Okay, and in the same way also, and at the same time, the narco test was taken against the wish of the accused, then article 20 subclause 3 comes into the picture of Indian constitution. What? Self incrimination. You cannot ask a person to self incriminate. That is why narco test is admissible, but it depends upon the authenticity and how the test has been conducted. Okay, and that's why One of the landmark case was the Kasab in the Selvi versus state of Karnataka, 2010. It was said that the narco tests are not admissible. But why? Because there the narco test became the secondary evidence. So if someone is giving the narco test, there also need to exist additional evidences to corroborate. Do you understand the meaning of this word corroborate? Corroborate means to match whatever is being given or whatever is the result of the narco test. This thing. Now, now I hope you have to just understood and write down this last judgment. In that is why in the Dayal Singh, in the Dayal Singh versus state of Uttaranchal, state of Uttaranchal, AIR 2012, AIR 2012, it was held that it was held that expert opinion, the work of the the work of the expert is to just assist the court, in arriving the final conclusion, full stop. The report given by the expert, the report given by the expert are not binding in nature, and if if there is a word used, if the eyewitness ocularly, if the eyewitness evidence if the eyewitness evidence are trustworthy, then it will be given more preference than the expert opinion. Okay. Now imagine for a minute if the expert opinion would have been made, it if it would have been made mandatory, then in Jessica Lal case the accused would have been declared guilty even by the Supreme Court or the High Court. Okay. So that is why, because if you see in the Jessica Lal case, the judgment was the Siddharth Vasisht, right? This judgment, Siddharth Vasisht versus state, AIR 2010, AIR 2010 Supreme Court. Full stop. The opinion of the expert, write down this and you can cite in your research paper and your moot court also. The opinion of the expert was was dash, like this was the evidence, sorry, this was the opinion, that it appears that it appears that two cartridges two cartridges cases are from two different pistol, means the two bullet which was which was shot at the Jessica Lal was shot from two different pistols. The defense had been relying on this principle, and even the expert also corroborated with the views of defense. And now why is the case? Even the expert opinion is also a human being. He also has lives in the same society. He also has his own ambition or fear, and as it's a human being, there are high chances is to be manipulated. So that is why the expert is just taken for the advisory purpose, and the advice of the expert is always advice of the expert is always advice it is the expert opinion is just advisory, and it is not, write it down somewhere, it is not binding to the court. Okay. Expert opinion is never ever binding on the court. That if the expert has given the opinion, then yes, we have to accept this evidence only. Okay. So, and also write down few lines, that an expert deposes, means he gives regarding the evidentiary value, he just deposes. The expert never decide. The expert has to just advise. The expert can never decide. And suppose if the court has to take now the question is, now if the court has to take consideration of the expert of, because now this is the last point and now we have a lot of time left, so we can take the we can I can take a lot of a lot of your questions also, because that was just small. It was very small topic, and I have given you few real life examples also, like Palani Garden case, Jessica Lal case, and please watch that web series Illegal of Piyush Mishra and Neha Sharma. That is one web series which is which comes to the nearest possibility, or it shows the it shows the Indian legal system closely. Otherwise, I don't think to some extent Jolly LLB first part, not the second. Um, it was more of realistic, the first part. Okay, but again, if you want to see the reality, it has to be the not the reality, the closest to what actually happened in the criminal code. Please watch this web series in league. Okay, now on what basis, on the expert opinion, on what basis the court decides that whether we have to rely on the expert opinion or not? First, the soundness of first reason. Write down the soundness. The soundness of the reason means whatever reason the expert has given, how sound those reasons are. Okay. Second, the material, the material or the material or the observation given by the expert in given by the expert in relevance to the facts of the cases, means how the observation given by the expert, how much they hold relevancy to the fact of the cases, all these things. Okay, so this was my small webinar. Okay, now I don't think nothing more has to be. I don't think that nothing more has to be taught, because I think I have summed up very nicely regarding the direct trading part, regarding my courses also, and regarding the conceptual clarity of the webinar in like 70 minutes. So now I'm open to your questions, and because I don't feel like overstretching it. So in case you have any doubt regarding this, now please go ahead and ask your question. And yeah, please do connect with me on LinkedIn. Thank you.
It was really amazing, sir. This was one of the best, probably one of the best events I have hosted so far. Like this was kind of too much of like it was carrying too ample of knowledge for the participants. I hope everyone really enjoyed it, and those who have missed it has missed something really great. So,
So yeah, if you have any questions, please, we have ample amount of time. Please go ahead and ask your questions.
so we have collected quite a few questions from audience. If
Sure,
till
please
anyone, yes.
go ahead.
A question is that what is the difference between expert and an ordinary witness?
I've explained ordinary witness is something. Witness, if it is a witness, he is related to the case. It can be prosecution witness also, it can be a defense witness also, but an expert is a person who has gained insightful knowledge, who has gained skills, and who holds expertise over a particular area. It can be like for check bounce, a check dishonor case. Usually if the signature doesn't match, or if by the defense it has been accused that the signature has been forged, okay, then the court has the power to call upon the witness. Section 311, 12, 13 of CRPC. The court calls upon the witness again. The court, and at that point of time, Section 45 of Indian Evidence Act empowers the court. Okay, it empowers the court to take a expert opinion. That's where they can bring an handwriting expert, and they will check. They will take their opinion that whether there is any kind of forgery or not.
And so this seems a kind of constructive question, but I have to ask. I'm supposed to. So it is like if there are two experts and like just two experts are there into the code of law,
Yes,
and
yes,
they
I understand. I was waiting for this question actually.
Yes, and they both have different opinions. Then, what would be the point of consideration for the honorable court?
Nothing, simple. The court will take both the opinion, and while forming the opinion, the court, the judicial or judge will decide that whose opinion he has to take or whose opinion he has to reject. Simple. It's not mandatory that no, he has to accept this evidence, this advice of the advice of this expert or that expert. It's not on the. It's not the case.
Yes, surely. And so, can you throw a bit more light on handwriting expert part?
Handwriting expert. Usually, it determines mostly it helps in the suicide cases. Have you seen the movie Bazigar? So what did the Shah Rukh Khan do? That when he killed that person, so instead of writing a suicide letter, he typed the he typed a suicide letter. Okay, just to rule out the possibility that just to rule out the possibility that if then expert comes and check whose handwriting is it. It's just that in normal circumstances, when you write something, so you develop your own kind of handwriting. Okay, so in even in the normal case, you can find out like in your family members also, you can find out that this is your father's handwriting, and this is your brother's handwriting, and this is your sister's handwriting. Okay, but if I tries to forge your handwriting, na, even I won't be able to do it completely. Somewhere down the line, I'll miss out on something, and that is where the handwriting expert, suppose I'm writing my name Rahul, so there are chances that that if I'm writing R like this, so I can make a spiral part, the rounding part of R. I can make R like this also. I can make R like this. So there, the expert shows that in all these cases he always write R like this, and in these cases the R has been written. So there, that's where he can highlight the differences. But again, it becomes at the Supreme Court, court, that how to accept that kind of evidence. Okay,
Yes, sir. I have also heard that if the with how much pressure a word has been written, this is also plays a role in determining that
how much pressure?
different person writes the same word with different kind of pressure on paper, and the way he is holding the pen.
It depends upon the criminals also. Okay,
Yes, sir.
usually expert opinion can highlight. That is why scientific evidence are not taken, especially the narco evidence, are not taken as a conclusive evidence. Okay, the court can never conclude something just on the basis of scientific narco test. Why? Because if it's if there is a criminal, if there is a criminal who is a very well trained criminal, or a spy, or an soldier, okay, or an expert who is well trained, he knows how to cheat the polygraph test, all these. So that is where the expert, that is where. But in the normal circumstances, in the normal cases, usually that's not the case. How much I will try, irrespective of the fact how much I try to copy your handwriting, there will be a certain, even if I practice for 10 days, no, there will be a places the expert can find out that yes, Madhur Rathore write W like this, and Rahul Tiwari writes W like this. Why? Because not on like suppose I'm writing something from your behalf. Imagine like this, guys, just wait, I have to give one more example of one more judgment. Please don't leave. So if I'm writing a letter on your behalf to someone, and I have written something obnoxious, and I have copied exact your handwriting, okay, but the expert can still highlight that here things have done, because suppose if your defense counsel uh, if your defense counsel is able to establish this fact that while this letter was being drafted, you were not there, means someone has written. And if I am made the accused that I have written, then the defense that expert can highlight that although in this letter this handwriting is used, but this person actually used write w over like this at the other places. He can show that yes, this is the case. So this is how it can correlate. And also expert opinion, guys, always remember, opinion are invited where the circumstantial evidence are comes into the picture. Now, what is circumstantial evidence? All those people who are writing a very informative session and all, please connect with me on LinkedIn, and please take my course also. It is the best, I would say, the most cost productive course, and please go through the syllabus once of my course, then I don't think you will have any complaint. So what were we circumstantial evidence? So when does the circumstantial evidence comes into the picture? The circumstantial evidence comes into the picture when there is no direct evidence and there are a lot of facts which is available, and you have to interlink all the facts. Means the chain of the prosecution, the duty of the prosecution is that they have to bind all the events, and they have to say that the chain of event is being completed. There is only one hypothesis which has been created and no other hypothesis is being done. And there, all those chain of evidence, when it gets completed, it gives a conclusive proof. But even if the court is not satisfied, or if there is some confusion, or if prosecution needs to explain a certain kind of art or certain kind of science or certain kind of situation to the court, that time the prosecution can tell the court that, my lordship, please bring any expert on the handwriting expert or fingerprint or ballistic or any expert and take his opinion also. And when the uh, expert gives this opinion, and the cross examination, Roshni Agarwal ma'am, please first connect on LinkedIn. Type Advocate Rahul Tiwari on Google. Connect with me on LinkedIn. I'll send you all the details. Okay, and you will find, and please first see the feedbacks also of my former students. So uh, that I have completed the chain of evidence. I have brought. I have brought what? I have brought. The expert also, and the defense counsel is not able to overrule my expert advice in the cross examiner. Then the court has to take into the consideration of the expert also, and he will say, yes, I'm accepting the opinion of the expert. My course starts from the 1st October, although it was earlier 24th of September, but few students have exams, and even I have my PhD exams, so I thought that I'll start with 1st October, and the course will complete in 1 month. Friday, Saturday, and Sunday, 12 live classes, 6 recording sessions, and all the recordings will be available till for 15 days. So the last recording of 31st October will be till after it will be available after Diwali also. Okay, so don't worry on that part. So that's where the chain of evidence, and that is where the court accepts the expert opinion. And write down one more judgment, the landmark judgment on circumstantial evidence. And the judgment is in the judgment of Sharad Birdi Sarda, Sharad Sharad, Sharad Birdi Birdi, Birdi Sharda Sharda, Sharad Birdi Sharda versus State of Maharashtra, State of Maharashtra, Supreme Court, 1982. 1982. It was held that circumstantial evidence are taken into consideration. Circumstantial evidence are taken into consideration only when there is no primary evidence available, and uh, the court is not able to come to a conclusion. Okay, that time the circumstantial evidence are taken into consideration. And what are the grounds? The chain of event has to be completed. Chain of evidence, events, chain of events. The chain of event should be conclusive in nature, means you can conclude something. Only one hypothesis, it should lead to all the chain of event, should lead to all or single hypothesis, and no other no other hypothesis should be there, should be there should exist should exist parallelly. Okay, so this was the observation given by the Supreme Court of India in the landmark judgment. Okay, now more questions.
If anyone like it was really informative. So if anyone has any other question, please put
Yeah,
on in
as
comment
well
section.
as asked about the merit, you will practice. You have to keep practicing the art of reading the merit at least 1 or 2 hours every day. For then, after 7 8 months, you will automatically see the results.
So I don't think so. There's still any question left. So as far as said, please connect with him on LinkedIn. Go check out his course for sure. And even Lex Sweeps has recently launched its course on intellectual property rights. You should check out that course. And since like all the attendees of this webinar will be getting a special discount, and even anyone else from the reference of Rahul sir, whoever is coming for that course, he'll be getting an additional discount for the same. So please check out our course on IPR and also Rahul sir's course.
Okay, so
I think so. We should wrap it up. Like it's
yeah,
good
yeah,
always
sure.
to finish on time rather than being late.
Yeah,
Thank you, sir. Thank you for coming and accepting our invitation.